When it comes to covering legal developments and developments in the industries that they serve, law firms think that they are in the business of breaking news. They think that by being the first to publish content about a legal development, they're showing the world that they have their fingers on the pulse of the areas of law they practice and the industries that they serve. What if I told you that being first to publish is a superficial, short-term win, and the better approach is to aim to be the first to be contacted? Law firms are not media outlets. Clients do not turn to them to get up to the second details about legal developments. There are many media outlets, including legacy media, email newsletters, and podcasts that perform this kind of service. Clients turn to their law firms to get an idea of the so what and the now what of legal developments. Now that this decision came down, what should we be thinking about? Now that this legislation has passed, what should we do now? Now that this regulatory action has taken place, how should we proceed? Too often, in the race to be first to publish, law firms do not include this so what and now what, because quite frankly, they haven't had enough time to think through the ramifications and repercussions of a legal development. After all, if you are writing about a legal development with the goal of publishing a few hundred words about it within a few hours of learning about the development, you probably haven't given much thought, nor could you expect to have given much thought to how that development impacts your clients. That's why I recommend that when covering legal developments, law firms don't focus on the first to being published, but the first to being contacted. Meaning, they produce the kind of analysis about a legal development that suggests to clients that they should be the first firm that the client contacts to learn more about the development and perhaps to guide that client through adjusting to and complying with that development. The key aspect of creating content about legal developments that positions a law firm as being the first to be contacted is making sure that the content actually speaks to their target audiences. If a firm has several target audiences, there's no reason why they can't have multiple versions of content regarding the same developments. Now, this should not be subtle in terms of how you call out your target audience. A piece of content regarding a legal development should call out the audience it's speaking to and should include specific details regarding how the particular legal development impacts that audience and what the audience might want to do now in light of that legal development. That's how you demonstrate your authority. That's how you position yourself as the go-to law firm for your clients. A recent client alert that I read proves this point beautifully and did a nice job of positioning themselves as first to contact instead of first to publish. Delaware's governor recently signed into law a new assignment for benefit of creditors act. Several firms covered this development within the first few days after the act went into effect the way that you would expect them to. They covered the substance of the act, such as what changed, but they covered little else beside the actual language of the act. 3 weeks after the act went into effect, one law firm published a blog post about it. But the post didn't simply cover the substance of the act. It explained in straightforward bullet points what two particular audiences of importance to the author's practice should know about the act: private equity sponsors and distressed acquirers. Now, let me be clear. Being first to publish and being first to contact is not mutually exclusive. If you can relatively quickly produce content about a new legal development that includes thoughtful, targeted analysis for your target audience, more power to you. To be fair, this pressure to quickly produce content about legal developments doesn't come from nowhere. Publishing speed is easy to measure and easy to reward. An attorney or a law firm who publishes first gets the visibility of being first. The law firm's marketing team gets an opportunity to record some metrics, and of course, no one wants to be the firm that looks like it's a step behind its competitors. Those incentives are real, but they're aimed at the wrong scoreboard. Producing content with the goal of being first to publish is the kind of content that rarely wins work from clients. But producing content that's designed to lead a firm to be the first to be contacted because it's substantive and targeted, that's the kind of content that leads to winning work. But you should not let an imaginary pressure to produce content about legal development as quickly as possible override the need to produce content that's helpful to your audience and provides them preliminary guidance about what they can do in light of the legal development that you're covering. It might feel good to be the law firm that was the first to publish thought leadership about a particular legal development. But I can promise you it will feel a whole heck of a lot better to be a law firm that is the first to be contacted by a current or prospective client about working on a new matter stemming from that development based on how you thoughtfully analyzed that development and explained how your current and prospective clients could be impacted by it. If you're interested in learning more best practices about thought leadership, check out lawfirmeditorialservice.com. We have more than 500 videos, blog posts, and podcast episodes that could help you do just that.